Randy Chase, Nashville.
Ronnie Tickle, Memphis.
Mark Brudd, Knoxville.
Keith Whittington, Johnson City.
Reese Smith, Franklin. Jerry Hayes, Paris.
Bill Mason, Greenbrier.
Cindy DeBus, Knoxville.
Motion.
Second.
All in favor?
Aye.
Aye.
Opposed? Hardships approved by the executive director.
So moved.
Second.
In favor?
Aye.
Aye.
Opposed?
Megan Buell was going to be here today to go over, she's the marketing director, but she just gave her notice and she will be leaving, so we will need to wait until they hire a new marketing director. But we have been meeting and she's got a lot of things in place for the new person that comes in to follow up on and all about, and they know about wanting to do some like radio ads and even TV ads, things like that. So we'll just have to wait until they hire someone. We are still waiting for it. Legal has been trying to get in touch with the court reporter to get that to us, and we haven't had any luck yet.
How many meetings are we behind?
This is only one.
Only one.
You can go ahead and do the waive first.
Move for approval on the waived interviews.
Second.
In favor?
Aye.
Aye.
Opposed?
I have several. If I can go do mine, if you want me to go ahead and do mine.
Okay.
On Quality Home Improvements, number 8103, he had a felony. His felony was for habitual driving without a license in Florida, and it wasn't DUI related. He's completed probation, and I recommend that, that's a home improvement, recommend that be approved. On TICS Roofing and Restoration, he wanted a name change. He had an outstanding complaint which I felt was significant. The name change has a very good reason for it, so it wasn't like, I wasn't feeling like he's trying to hide from his complaint. So I told him that we would approve the name change contingent on the board staff confirming with the complainant that her work is now getting done by another company that he agreed to work with. That doesn't necessarily mean his complaint is dismissed, but that that she is getting the work done. So that was my recommendation on that. On Home Improvement 8126, which is C&M Construction. This gentleman appeared before us a couple of years ago and was still on probation. He is now off of probation. We had an old, turns out an old complaint against him dating back to 2007, at which time we recommended a $1,000 civil penalty. I talked to him at length about that old violation. 2 years ago when he applied and we denied him, he paid a $250 fee, which he didn't have returned. He didn't ask for it, so we never returned it. After talking to him about that complaint and hearing all the details of it, my recommendation is that we approve his application for a home improvement license, that we, of course, he's paid another $250 for this license. We kept the previous $250, and that he pay an additional $250 civil penalty to satisfy that old complaint, and which I think would be appropriate under all the circumstances. So that's my recommendation on him. And on 68944, a limited license for Gonzalez, he was fine. I move that that be approved. So on those four that I just mentioned, I move approval under the circumstances that I detailed.
Second.
In favor?
Aye.
Opposed?
All right, now I have another one, though, and the gentlemen are here. This is Dyer Need Corporation, and the names of the gentlemen, one of them's named Dyer and one of them's named Needham, so that's the name of where that comes from. Mr. Needham has a felony conviction for forgery and I believe embezzlement or something along those lines. He is still on probation. He is 50% owner of this, and he is appearing here with his co-owner, who is also a 50% owner, and wants to make the case that he should be granted a license despite being on probation. Wasn't willing to make that recommendation or to recommend denial either, for that matter. And I explained to them that in my time here, we've only one time that I know of allowed someone on probation to have a license anyway, and that was, we felt like under some unusual circumstance with an extremely long probation period. And so I'm going to ask them to come forward now and make their case, to explain what he did, explain the terms of probation, explain who the co-owner is, and try to make his case. Yeah. Identify yourselves before you talk.
I'm Paul Needham, and I went through a very rough time in '99 to 2003, going through a divorce, and I had a couple little businesses, and I had signed my mother's name and used her name for credit, and I got charged and arrested, and I was very shameful, but I was also in a mess. And my daughter had been taken from me by her mother. I couldn't see her. And then I was working with another business, and I actually took that money to pay personal bills and to pay child support to my wife to try to stay out of jail. And I was drinking at the time, and there's no excuse for what I did. I was a fool, and I got arrested, and I spent time in prison for it. And during my time in prison, I got 3 degrees, but that doesn't really matter to the Contractors Board. And I've been home 2.5 years, and I knew Mr. Dyer prior to my incarceration. He's also my minister at church. And I've been working with him at the church for the past 7 months doing a project for the church. And I have a license to do lead work, but with the loopholes in the laws has changed so much, you can't even do a job under or over $3,000 without a contractor's license anymore. And I can't even do lead work unless I have a contractor's license. And I really don't have no means to get an income, and with a felony on me, you can't even hardly get a job at Home Depot. And I've done construction off and on my whole life with the Testermans and the Shods and the Schuberts in Knoxville in many trades, so I don't know what else to say. So, and I want to do what's right. I don't want to break any laws, so I'm not going to try to do any loopholes. I tried to be transparent with everything, but I can't even do a lead job without a contractor's license. And most lead jobs are going between $30,000 and $40,000 for abatement for windows and substrates and all that stuff. If you go in and change windows and do all the exterior siding, the excavation work, so thank you.
How long are you on probation?
I've got 3.5 years left. And it's really been a struggle to try to find a decent job to pay certain restitutions back, and it's been a struggle for 2.5 years, and You know, my probation or parole officer been working with me, but it's just a struggle. And Home Depot won't even hire nobody. And I just know construction.
Did you take the contractor's license test?
Yes, sir.
Do you know what your grade was?
79 or 80 on the trade and 89 or something on the business law.
Probation?
I came home from prison. That's what I'm on. I'm on the last part of it. March of 13.
Bonnie, he had a 74% on business and law management and 79% on the BCA.
Anyone else involved other than your mom?
No, I done it myself. There was no.
No, I mean, was she the only person? Only victim? Thank you. Was your mother the only victim?
Yes, well, then my business partner was at the time. Well, not
Yeah.
really my business partner. I really don't want to say much because it's kind of some of that,
Better say, you know.
it's,
You left that out.
he was on drugs.
Well, you
Okay.
said it was just your mom, but
On the
now,
first part.
yeah,
On the first part, when I signed her name.
right.
The second part of embezzlement, I done that on my own from the company. So,
When did you do this? What year?
right around 2005 and 6.
50% owner of this new company? Yes. And what is your experience now? The gentleman with you is the other 50% owner.
Sir,
You want to tell us your name, what your experience is in this field?
Yes, sir. My name is Kenneth Dyer. I'm the pastor at Harvest Christian Fellowship Church in Knoxville. I've been in the community. Well, actually, I was born and raised in Knoxville. And I've been at this particular location for over 20 years, working in the community with drug addictions, alcoholisms, homelessness, distribution of food. So I've worked with many different people. And I've known Mr. Needham since about 1998. We were friends then through some of the folks at my church from New York. When he got out of prison, he came back to my church, and he's helped us extensively since then, working in our food pantry. Again, and the reason I gave all the background there about working with different people, being in the ministry for almost 30 years, I have a pretty good judge of character, and I have a huge record of second chances, giving people second chances. I hired Mr. Needham. We were doing some construction work at our church for our food pantry. I hired him as a foreman. We have worked very well together. Again, I trust him enough that I would go in business with him. And so I feel that, and I don't know all the laws about the contractor's license and so forth, but as far as people is concerned, again, I trust him. I would stand behind him. I would back him up. I would take responsibility because I know the struggles that he, as well as many others, have had when they came back from being incarcerated for whatever reason that might have been. It's a very huge struggle. We have given several people chances after they've gotten out of prison. Our custodian, before he died of cancer, had been incarcerated, and we gave him a job because that's what we're in business for. But in this case, I trust Mr. Needham. Again, I've known him since 1998. There were some extenuating circumstances to that whole situation. I trust him fully. And I'm in business with him and would stand behind him and will answer any other questions that you might have.
Have you put 50% or more of your own money into this business?
Yes, I have.
And you signed the guarantee agreement,
Yes, I did, sir.
Joe, how much are they asking for?
$175,000.
And I might add that there's a lot of people in the Knoxville area that is very well acquainted with Mr. Needham and the situation, and they have let it be known that once he gets a license for our company, then they would be very much willing to let him do the work. So, if that would help.
Understand that if y'all are in partners and you are granted a license, if anything happens, then you are very much responsible for whatever goes wrong.
Yes, I understand that, sir.
Okay.
And I take that responsibility willingly.
What class is it for?
BCA.
Okay, I have questions for Mr. Needham. Okay, Mr. Reading through your paperwork, so you had a contracting and carpentry business back in,
Paint, concrete, and carpentry.
and that's the business you lost by signing your mom's name?
I lost all that through a divorce,
Lost that through the divorce, okay.
and that's what got all this going.
2006, you took funds from a company that you co-owned for personal use and bills in 2006. Okay, and then expired tags, okay.
I didn't even know they was
Had
expired
a
then. I got
judge
pulled over.
warrant, okay. Okay, then 88, wrote a check to somebody, you knew it was bad.
Well, actually, I stopped payment on the check because my car messed up, but I got arrested for
Got
the
arrested for that.
for the bad check, yes. I was 19, I think.
Make restitution?
I'm working on that right now.
You are in the process of doing that?
Yes, and it's just hard making 10 or 12 bucks an hour or 14 bucks an hour.
Start making restitution?
Yes, yes, sir.
Are you under court order to do that? You
Yes,
on your
court
own?
order, sir.
Okay.
A lot. Yes. Can't forgive myself, but yes.
Tatum, I know it's been our practice that we don't license a contractor that's still on probation. I mean, I don't know,
I understand.
I encourage you to hang in there, but well. I'll have to vote no just based on past experience of not licensing a contractor that's still on probation, because our job is to protect the welfare and safety of the public. And I know you have a great witness to vouch for you, but if something comes up and you, just one little thing, and it's even perceived that you did something wrong, then it's gonna come back for the board that we gave a contractor's license to someone that, licensed felony that's still on probation. So that's, just so you know, that's where I'm coming from.
Ask you this, what would be the chances of you taking the test and being the qualifying agent of your company per se? Okay. That's fine, that's fine.
Well, you could get anybody, I mean, you could get a relative, you could get somebody to be your qualifying agent, and then you could hire him. That's the fallacy that we have here. Somebody could come get a license and hire this gentleman the first day and put him on the job, but
I was just trying to help.
Yeah, sure.
to show you there is another avenue
Right.
that we do have to help.
Is there a motion?
Well, you know, he wouldn't even have to take the test on a limited license up to 125. You just have to go on a limited license that we have, you just have to complete some 30-something hours at a junior college, one night a week for a while, and then there's no exam. And-
We need to be sure we're not advising you to find a way to circumvent the law.
No, I
We're just
understand.
suggesting that there are other avenues of setting up a business that you may want to
Or
consider.
a license,
Right.
Yeah.
and you can do work up to $125,000, which is not too far off of what you're asking for a BCA
Right.
license, and you just kinda have to go to classes and get it, and then you could do that.
What specifically would the courses be? I mean, so that I would know what to even apply for.
I think
in
the best
in-
thing for you to do, depending on what happens here, is talk to staff about that. Okay?
They're here, they can talk to you after the meeting.
Well, the reason I brought y'all, because I think, as much as I regret it, I think Cindy's point is well taken. So I move that the license.
Second. Aye.
Those not in favor?
I'm done with my interviews.
I have two.
Okay.
Okay, make a motion that we approve 68863 and 8105 based on that they did have felony, but they not been in trouble since. The probation has expired for several years for both, and no prior complaints. So make a motion that we approve those two.
I've got one. It's license number 68713. Multiple felonies dating back to 2003, the last been in 2008. Probation has been served, sentence has been served. Guy's got his life back right and has passed numerous state exams in South Carolina and North Carolina. Took and passed our business and law, our BCB exam. However, I couldn't find any experience or any knowledge in the company to grant them a BCB commercial license. So we got to talking, and he's going to go back and take the full mechanical exam, and then we're going to issue certain classes, BC 19, 31, and 32, along with the mechanical license. And I just make a recommendation that in talking to the guy and reading through all the paperwork and the release from probation and everything, that we approve this license pending receipt of the mechanical exam. A good score.
Aye.
I've got a couple that we need to review. It's license number, starting with license number 68909. This gentleman had a felony in Florida. Actually had several of them, all occurred at the same time back in the late 90s. Reese and I both talked to him. I think he served 2 years house arrest and 3 years of probation. He's been off probation since 2004. As soon as I think he sort of stated he got mixed up with the wrong folks when he was 18 or 19 years old, and and sort of paid his dues. He's been fully employed since that time. And he's got quite a resume of he got his high school diploma, got a 2-year associate's degree, multiple HVAC degrees or certifications. He's really pretty impressive young gentleman. So all his financial stuff is in order. He's looking to just get a $50,000 CMC -C license. So I would make a motion that we grant him that license.
Aye.
And I got one more. It's another gentleman with a felony. The felony was in 2007. He's been off probation for about 3.5 years. He's looking to do swimming pool construction. He's been doing that for other contractors for several years, even before the felony. And he's looking for a $300,000 license to do pool contracting work. His finances are in order. He's been on the straight and narrow since his felony. And I make a motion that we approve his request for a license.
Aye.
Now, Randy,
Yeah, it's BC 5, 13, 15, 19, and 26, everything that's sort of associated with building a swimming pool. Those are the,
I mean, sometimes you just would do BC, just swimming pools.
okay.
Because the other is work incidental there too.
yeah. It's just the way
Okay.
it was.
Okay.
So moved.
Second.
Second.
Those in favor?
Aye.
Opposed? Okay,
Approve the LLEs that are listed, except for 33065. Will hold those dependent upon an exam score.
motion.
Second.
Those in favor?
Aye.
Opposed? LLP.
It was just one. It was a reinstatement. Motion on that?
I need to tell the number that it was or anything? What did I do with that? 889. I make a motion that we approve the LLP.
Second.
Aye.
Opposed? Next,
I thought maybe we might want to go out of order with the agenda since we have people here, and then Young with the Go Build, go ahead and have him give a presentation.
Morning. I want to thank you for allowing me to be here. I'm Bill Young, the current Executive Vice President of the Associated General Contractors of Tennessee. We represent the offices in the branches in West Tennessee, Middle Tennessee, Knoxville, and Tri-Cities. You're very aware, we've had several discussions about Go Build. You probably remember Johnny Stites was kind of the impetus on this. He went to a meeting a couple of years ago and saw a presentation from the gentleman putting on the Go Build Alabama program, a guy named Bob Woods. A little side note, Johnny Stites is no longer in the construction industry. He sold his company to his brother this past spring, and he's now working in the Governor's Office of Consumer-Focused Government. So he can no longer participate in Go Build, can no longer participate in AGC or any other association activities because of his conflict of interest with working for the state of Tennessee. You also remember Ryan Williams. Ryan was the state representative who introduced the bill in the House. He also worked for J&S Construction. If you remember back in the spring, we had the conference call with Representative Williams to clarify exactly what the bill was and how it was going to be funded. And just to let you know, when the bill was, and a lot of lobbying efforts from the four major associations, the home builders, AGC, ABC, and the road builders went on. There was a lot of misinformation that was out there. But bottom line was, on April the 22nd of this year, the bill passed 95-0 in the House. There was no opposition in the House. In the Senate, we had 26-2. The two, one being Senator Gardenhire from Chattanooga and Senator Nicely from Strawberry Plains, and Senator Hensley was present but not voting. I'm giving to Carolyn several documents, one being the actual statute. It's Public Chapter 500. A couple of points just to I'm not going to obviously go over the whole thing with you, but on page 2 of the statute, it shows what the composition of the corporation's board of directors will be, and it's an equal number of representatives of commercial and industrial building contractors and subcontractors, residential building contractors and subcontractors, and road building contractors and subcontractors. And after the bill passed, there were several meetings with the chief staff people for AGC of Tennessee, AGC of East Tennessee, the Home Builders Association of Tennessee, and the Tennessee Road Builders Association to discuss what we do now. This bill passed, I don't want to say quickly, but once we hit the ground, we have certain timetables we've got to meet. There was some discussion and legislative issues that came up about oversight, about monitoring, and I just want to point out a few things about that. We decided, we being the staff from the four major associations, that each of the associations would have 3 representatives on the board of directors. The staff would serve as ex officios and just serving as in the capacity as staff for the board for the time being. We had a meeting 2 weeks ago on the 7th of July, and the corporate charter, which you should have a copy of, lists the 12 members on page 3 of that charter from AGC of Tennessee and AGC of East Tennessee, AGC of Greater Tennessee, which is Middle Tennessee, and ABC, Middle Tennessee, and Knoxville combined, and then the ABC of West Tennessee. The Home Builders Association has 3 representatives from across the state, and the Tennessee Road Builders has 3 representatives from across the state. And they have met, they have reviewed and adopted the bylaws. The charter has already been filed with the Secretary of State's office, so the charter is there. They have elected officers. The president of the Go Build Tennessee Board of Directors is David Stansel from Stansel Electric, representing ABC. The vice president is David McGowan from Region Homes here in Nashville, representing the Home Builders Association of Tennessee. Alex Ray from Smith, Seckman, Reed in Memphis is representing the Tennessee Road Builders Association. And Tommy Burleson from the AGC of Tennessee, from Burleson Construction in Johnson City, is representing as the treasurer of the board of directors. We've established a bank account with Pinnacle Bank here in Nashville. I'm getting the signatures on that tomorrow. Tomorrow will be our second meeting, and we have a presentation that was submitted to us by the Go Build Alabama for being able to use as a license agreement with them all of the documentation, the publications, the ads, everything that they've done so far. We will be in the if the board agrees to this this proposal that was submitted to us last Tuesday, tomorrow we'll be hitting the ground running. There were several questions about again, the composition of the board will be the representatives from those 4 major associations. The oversight on this, and again, this is due to a lot of the legislative process and questions that were raised by the legislators. We will be monitored and measured by performance audit standards by the Department of Labor and Workforce Development. Again, these are all on page 3. The corporation will submit quarterly reports to the Commissioner of Workforce Development and Labor. We will submit an annual report to the Governor, the Speaker of the House, and Speaker of the Senate, and we'll have also an independent audit that will be submitted on an annual basis to either the treasurer's office or the comptroller's office. I've tried to be comprehensive in my report. Do you have any questions of me?
Who's your legal counsel?
Is Smith, Smith Cash and Orr.
Now, the legislation in section 49-105, section C, gives this board, in consultation with y'all, the ability to designate rules about dispersing funds.
Right.
Now, that's optional for us.
Right.
And, of course, it goes on to say that it must be spent for what it's for, which we're not too worried about that. But do you think we need to do that? Or do you think it would be, I mean, we have an option of doing that now or any time in the future.
Right.
And I'm not necessarily interested in us going through a process of rulemaking, but we have that option. And one of the things, that, of course, as you know, this board at first didn't want to even endorse this program.
Right.
And after the special meeting with the legislator, we agreed that, and then Mr. Smith did some representation of this board, which we're all satisfied with, of course. But one of the things that I certainly brought up every time is that I wanted us to have this option, to have some kind of control, since you're taking so much of our money and not even being administered through this department, but through the Department of Labor.
That was the legislators. That was.
I understand that, but I'm talking about the way things worked out, the realities of things. So I'm fine with us doing rules if we think it's necessary, but as an option or an alternative to that, unless the board wants to go ahead and have rules made, which we can ask council to devise for us, would be to have a very regular and frequent submission to this board of how the money is being spent on a specific line item basis rather than just in lump terms. You know what I'm saying?
Yeah, I do. And since we're doing the regular reporting to the Department of Labor and Workforce Development, I would suggest either having someone, either staff as ex officios or someone from the board making a quarterly report to this board. And by the way, there is a 4-year sunset on this. So it's even right now, unless something, and this is what I'm trying to tell these guys from Go Build Alabama. They're talking about, well, this is what we're going to be doing in 2 years. And I'm saying, no, we don't have 2 years. We've got to have this stuff ready to go. These publications and the documents and the hats and the ads and all that ready to go this fall. Now, the only thing that I don't know, and I was not in the meeting. I know that Bob Pitts from ABC and Kent Starwatt from the Road Builders went and met with the Commissioner of Labor and Workforce Development about the performance metrics. But there's nothing in here on the transfer of money, and that's one of the issues that the bank has. Do we set up wire transfers, or is it going to be a check deposited? We don't know that yet. But I would personally recommend having either someone from the staff come to this board on a quarterly basis. And do you have any problem? I'll bring that up tomorrow at the board meeting. Okay, I would suggest, since we're already making these quarterly reports to the Department of Labor and Workforce Development, they will also come and make the same report to you.
Well, I think that's the very least we would expect. And and my feeling about it, and and I'll quit talking in a second, but my feeling about it is that we don't need to make rules right now about the disbursement, and that we can leave it to your board, since it is optional to do that, but that we reserve the right to do that at any point in the future that the board feels necessary to do so.
This board.
Right. And that's what the
And that's what
legislation
statute says. And
that's what the statute says.
Yeah,
We
right.
reserve the right at any time to do that, but we will ask you that when you make your reports, to make them as detailed as practicable, to let us know exactly how the money's being dispersed and spent.
No question. We can do that. No problem.
So I would, I think we want to kind of make that a requirement of y'all in lieu of making rules. because we decided to make rules, and you'd be prohibited from spending money for quite some time.
No question about that.
So we don't, and nobody has any interest in inhibiting the program. I certainly don't. So-
Again, the statute itself pushes this board to act pretty quickly.
So that would be my recommendation. I don't know if we need to vote on it, but just to allow them to proceed without rules from us, but reserve the right to do so, and that on the agreement that they're going to make at least a quarterly report to this board about the expenditure of funds.
And if you'd like for Carolyn to come as an ex officio, not as a member of the board, but when we've got staff people in the room, but have her as the direct liaison between the board for Go Build and the board for licensing contractors.
Her or her designee.
A designee,
'Cause
absolutely.
She stays kind of busy,
Yeah.
so. But
We
whatever
serve
she-
lunch, so.
That'll be fine.
I thought we were supposed to have somebody from our board on that board.
It was-
That's what we talked about, and then we had Reese go up and talk and try to get things squared away as to what was going on, and then I see that there's nobody from our board on this. And so Mason, I know we talked about that.
And it didn't work out in the final version, but
Notice in the statute, now, in the whereas portion of the chapter on the front page, it mentions associated builders and associated general contractors. Our experience has been that especially in the previous administration, there was a bill that was passed in the legislature that gave associated builders and contractors and Tennessee road builders and associated general contractors the ability to submit to the governor's office specifically from those associations. And the previous governor vetoed it. So right now, your statute only allows the Home Builders Association of Tennessee to submit that list for submission to the governor for nominees to this board. So that intentionally was left out as far as naming the associations. And a lot of this was, when you specifically say, in that section C, when it says specifically career opportunities in the construction industry, that are secondary schools in this state, post-secondary schools, the TCATs, and other community colleges, we didn't even write that. That was written by one of the senators, that was an amendment to the original bill, and before it passed in the Senate, that specifically had to be on there. And if you note, it does not address apprenticeship programs, which I suggested, but it didn't get included either.
y'all didn't get your way either all the way.
No, we do not.
Bill, has it been determined what the metrics are that?
No, not to my knowledge. I did not attend the meeting with the Commissioner of Labor and Workforce Development, so I don't know if they may already have those metrics set up. Supposedly, I was on the phone yesterday afternoon for about an hour with a gentleman from Go Build, Alabama, and they already have those metrics set up in Go Build, and I got an email this morning that may incorporate what the state has with what they do. With what they already do. And I know I was talking to them about another component of Go Build, Alabama was job posting. Once these students graduate, where do they go, and who follows them in their career? Do they go from a plumbing class to horticulture? We want to make sure that they stay in the field that they were trained in. I mean, I got a master's degree in biology, and look what I do. So.
Everybody's aware, does everybody know that Bill will be retiring in 4 months?
I've put in 35 years in the association business, and I think that's enough. So. I've enjoyed it. I've enjoyed coming down here, and I appreciate you working with us over the years. It's been a pleasure and an experience, to say the least. Thanks.
Mr. Chairman, I'd like for us to go on record then. I move that this board not proceed with promulgation of rules in accordance with House Bill number 24, but that we do so on the understanding that the corporation will provide regular and detailed reports to this board about the expenditure of funds.
Second? Second.
Those in favor?
Aye.
Opposed? Motion passed. Now.
Thank you. Changes on my legal report from my recommendations. Number one, under residential, the board decided to authorize formal and send a consent order with civil penalty in the amount of $500 for improper installation of windows and improper caulking around trim. Next matter that I found additional information on under residential was number 20. And we were kind of going back and forth on the recommendation there, and I have since obtained the other inspection report. There was 2 houses built in close proximity to one another by this respondent, and our inspector found there to be gross negligence and/or incompetence on both of the structures. Therefore, my recommendation would be to authorize formal and send a consent order for $10,000. That would be $5,000 for each separate residence. And if the residential committee is okay with that, I will proceed. Yes, if you would.
Second.
Yes, sir.
Those in favor?
Aye.
Opposed?
Thank you. Number 23 under residential, the decision was that authorize formal and send a consent order with a civil penalty in the amount of $2,500 for poor workmanship in violation of TCA 62.6.118. $33 is coming off this legal report. I didn't have enough information to present that one. Number 37, the change was made on top of authorizing formal and sending a suspension consent order seeking voluntary suspension of respondent's LLP license for a period of 6 months. There was also the recommendation and authorization by the board to send a civil penalty attached to that of $5,000. Under commercial, number 5, rather than closing, the board has voted to dismiss this matter. Number 7, the board has voted to dismiss this matter. Number 9, the board wishes to dismiss this matter. Number 10, the board wishes to dismiss that matter. And same on number 12, the board wishes to dismiss that matter. Number 17, the board agreed with council's recommendation with one addition that we send a letter of information to the permitting authority in Shelby County and/or the city of Memphis regarding the issuance of building permits that are far in excess of a contractor's licensing limit. Number 19, the board agreed with council's recommendation other than we are going to close and flag as to respondent number 2 in that matter. Number 20, the board voted to authorize formal and send a consent order with civil penalty in the amount of $5,000 for failing to fully comply with the investigation or submit information requested by the board regarding this open complaint. That was all the changes I did, or I believe, hold on. I had a couple of matters that I think we skipped or overlooked on the residential. They were residential represents. And And I didn't get authority, I don't think, on those, if you guys had any changes. Number 1 on the represents, I can read it if it would help. It says, complaint was originally presented in May of this year, and the consent order was authorized and sent for $1,000 for failing to pay a subcontractor an amount of $1,900. I was contacted upon their receipt of that consent order. Respondent provided a copy of the canceled check showing payment to complainant in the amount of $1,950. And I explained to the respondent the importance of responding to open complaint in writing, and conveyed that to respondent's secretary. I'm bringing it back before you today to see if the board would be okay with authorizing a formal and sending a consent order in the amount of $500 for failing to timely respond to an open complaint, since it does look like they've made payment to the subcontractor.
Was the payment made in a timely manner, or was it?
Well, it looks like it was made,
After we contacted them?
it might have been after the complaint, but
Okay.
it looked like they thought that the matter would, I guess they just didn't want to respond, or thought that they had resolved the matter by just paying the money to the,
Might be a typo,
sub.
but there's $50 difference there.
yeah,
That just-
yeah, the check that I received looked like it was for $1,950, and I think that the complainant had told me it was $1,900.
Move for approval, $500.
Second.
Aye.
Aye.
Okay, thank you. Number 2, this was also originally presented in May, and the consent order was for voluntary suspension of respondent's license for 1 year based on our inspector's findings. However, after this inspection was done, respondent provided an engineer's report of the property in question that states proper reinforcement of the basement was performed and that there appeared to be no issues. Therefore, my new recommendation is issue a letter of warning to respondent company regarding following proper building codes in the future, and close as to the individual owner.
That's just part of your legal report.
Yes.
Okay, we'll just deal with that in the entire different.
Okay, I'm sorry. These are just represents, and I was just trying to get them. I think we overlooked them in the residential subcommittee. Number 3, on the residential represents, this complaint was originally presented, and board accepted council's recommendation of authorizing formal and sending a consent order with a civil penalty in the amount of $3,000 for what at the time appeared to be engaging in unlicensed contracting or construction management activity. However, upon further correspondence with the respondent, as we were prepared to set the matter for formal hearing, it was ascertained that respondent had engaged an unlicensed contractor to perform work upon a house which he owned. Respondent therefore feels that he is exempt under the owner exemption, and that the unlicensed contractor, who has already admitted fault and paid a civil penalty, should be the liable party. The facts do not show that respondent actually engaged in any work or acted as a construction manager, although it is believed he is in the business of flipping houses. Therefore, my recommendation is to issue a letter of warning regarding the board's position that the homeowner exemption does not apply if construction by the owner is done for purposes other than the owner's own use, but not for resale or lease.
Is that actually his residence?
I don't believe it was his residence, but he hasn't really admitted otherwise, although it's believed that he's flipping houses and in the process of rehabbing these homes for profit. But there was also another respondent attached to this complaint when it came in, and I think we sent him a letter of warning. And so I think that under the circumstances, a letter of warning would be appropriate here, because this guy is basically doing the same thing that the other guy was doing. We just don't have the evidence to prove exactly what he's doing because this unlicensed contractor has already signed a consent order saying, yeah, he did the work and he was unlicensed at the time. So it's kind of a, I guess I would say, a gray area.
If it's not his residence, it's not gray at all. He's in violation of the law.
Yeah, I mean, I understand the wording of the statute, and I agree with you on that, but he's just gonna, I just know that at a formal, he's gonna say that he's the owner of the house and that he engaged an unlicensed contractor and that he didn't actually direct that contractor. And I don't think that we have the evidence to show that he actually, I think that the theory was when we sent the original consent order that he was engaged in construction management, but based on the unlicensed contractor signing the consent order and admitting to complete fault and complete liability, I don't know that we can.
It'd be easy enough to find out if he lived there or not, shouldn't it?
Well, yeah, but I'm saying I think that the original theory was construction management, not actually performing any work. And now we're going to have a hard time saying that he directed an unlicensed contractor in any way because the unlicensed contractor said, yeah, I did the work and admitted to it by signing the consent order.
In other words, we've got somebody that had admitted that he was guilty,
Yes, sir.
and he's already fessed up.
Right.
And this guy, we don't know about anything on him because he hadn't said he's guilty or not guilty.
I mean, yeah, I don't believe that it's the,
But the reality is that he's probably flipping houses.
yes.
And doing it without a license.
Well, he's flipping houses, but his contention is that he normally, except in this circumstance, uses licensed contractors.
I think we'll have to, until he gets.
Right. I mean, there was another respondent that's doing the same thing as far as flipping houses, and I think he had a complaint with the real estate commission, but we had already heard that matter and decided to send him a letter of warning because of the lack of evidence that we had there. So I think that this guy's doing the same thing, but due to lack of evidence and the other circumstances with the unlicensed contractor, that based on the evidence I have in this complaint, that it's not the best one to go forward on a formal hearing.
I think it'd be worth our while to, if you know approximately where he is and who he is, have somebody just does something like that, then he needs to be brought before us. I mean, we are.
Yeah, I mean, we did do a full investigation on this, and there just wasn't. He's just always going to say, he's just like he's always going to say, well, I'm using licensed contractors, and then if that doesn't work, I'm not doing any construction management.
Well, what somebody's gonna say ought not necessarily guide what we do.
No,
I
I'm
mean,
not suggesting.
we wouldn't have any complaints that got followed through at all if we don't know what they were gonna say about it.
No, but I'm just saying here he has a legitimate case because he's using an unlicensed
Think he's got
contractor.
defensible
I understand about this case, but I'm saying it looks like there's something going on that's not up to board. And that we know that's happening, and we need to monitor it. And if something is going on that is not kosher, then we need to do something about it.
Right. Well, here, I mean, we did try to push the issue by sending him the consent order in the first place, but based on the fact that the unlicensed contractor has already taken full responsibility for it, it's going to be hard to go forward on a formal against. Yeah.
I understand what you're saying on this case.
Right.
I'm saying, if I was in Johnson City, and I knew that Keith Whittington was doing a bunch of houses, and I knew something didn't smell right, I'd be calling up here and I'd check, and then I'd have somebody investigate it. And if Keith was wrong, then Keith would be up here before us. I wouldn't let Keith just keep on and on and on because he's interfering with my business, because I am legit. See what I'm saying?
Mm-hmm. The next one,
I'll move that we accept your recommendation on that begrudgingly, because I think that at some point in time, this needs to be used as deterrent. Right. And we're not sending a message out properly. But since we've set a, as it seems, a precedence is what you're saying with another case, then we just need to, I'm with Ronnie. I don't know how we police it. There's no way to police it. It'll have to just come in as a complaint before we can investigate it. But still, I would like to see deterrent made to stop this, because it does happen a lot.
Exactly. And in your letter of warning, you do send that? Who sends a letter of warning? You do? Language, if you can, let him know we're on to him.
okay.
Aye.
Number 4 under represents on residential. The prior recommendation on this one, this is a 2014 case, but prior recommendation was consent order with voluntary revocation of their home improvement license. Their license has since expired due to failure to renew as of January 31st of 2014, and the grace period has passed. Therefore, since there's no license to discipline or revoke, the recommendation is that this matter be closed and flagged.
I have to vote on every one of these individually.
Okay.
Carry on.
2 more and I'm done. This one was a 2011 case and looks like it was under litigation monitoring. Litigation has concluded. Respondent was found to be in breach of contract. And, well, it didn't look like I finished that one. I plan on coming back to that. I think that they got a judgment assessed against them in civil court of something around $2,800, and that was to be paid to the complainant / plaintiff in that matter. I believe that they have.
Sure, do you believe?
Think and you believe.
Yeah. Well, I know that it was a pretty small civil judgment.
What's your recommendation?
That it be closed and flagged. Okay. I'll look into that one. Okay. Number 6, we issued a consent order in the amount of $3,000 for unlicensed plumbing. Looks like the complainant here, the respondent had sued for the $3,000 that he was owed under the home improvement contract. The complainant countersued for a ridiculous $1 million in damages. And then the complainant was then accused by the court of holding himself out as a licensed attorney, perjury, and bringing a frivolous lawsuit. And then the suit was dismissed. Respondent admits that he engaged in some plumbing activity that was not exempt under the LLP laws, but states he did so unknowingly and will not be doing any more such unlicensed work in the future, and is requesting either a reduced civil penalty or a letter of warning. He was barely above the $500 limit, and while some of it, I believe, could be unlicensed plumbing, I think it was minor, and based on the complainant's conduct, my recommendation is issue a letter of warning regarding engaging in plumbing activities that would require an LLP license. That's it. That's all I've got on my residential represents. We did all the commercial. The only changes were on the addendum here. Number 1, rather than just closing, we're going to close and flag. And I apologize, there is one residential on the addendum. The complaint alleges the respondent failed to address issues in punch list items. The original civil penalty was for $2,000 for failing to address consumer concerns and providing poor workmanship. The litigating attorney has discussed this matter with the respondent at length, and it appears that respondent addressed all of complainant's issues with particular respect with the plumbing issue that was the original basis for the complaint. The electrical work was approved after respondent made necessary repairs, and subsequent investigation found complainant still had issues with tiles, drywall cracking, uneven / different color painted walls, and gaps between ceiling trim. And the respondent returned to the residence on numerous occasions and addressed complainant's problems. And also the complainant still owes respondent about $600 that was never paid. And the litigator feels that since the original complaint stemmed from the electrical work issue and has been resolved, we cannot proceed in this matter. Respondent has been in the contracting business for 20 years, and this is only his second complaint. And additionally, respondent has advised that the complainant made several referrals of his services to her family and friends.
What's your recommendation?
The recommendation is that this matter be closed.
Move to accept the legal report.
Second.
Those in favor?
Aye.
Opposed?
Yes, Shalina, do you want to present the appeal reconsideration or consideration?
Good afternoon, board members. This is a possible reconsideration of an appeal. It's the Rodney Leatherman matter. However, we have a little problem. This was noticed for you to reconsider tomorrow. However, tomorrow's meeting has been canceled. So we're going to have to reset this for the next board meeting in September, which will work out because I have just recently heard from the respondent after approximately 9 months, and he would like to appear. Now, it's not for the actual reconsideration or appeal of the matter. It's just whether you will reconsider it, if you understand what I'm saying. If you'll hear the matter again, because the ALJ has already issued an initial order. So he would like to request that the board rehear the matter. So I just wanted to let you know that I heard from him this morning. This has been a pending matter since last October when he appealed.
We have to wait till next time to make that decision?
It would be better if you heard from him as well and give him the opportunity to appear.
Well, wait a minute. Do we even have to hear from him? We've got a written appeal that was distributed to the board, which I've read through. I've read his appeal, and I've read the judgment of the administrative law judge. And my understanding is, Counselor, that we don't have to hear from anybody. We can just rule
that's
right
correct.
now whether we're going to hear an appeal or not.
That is correct.
We don't, we're not obliged for him or you, for that matter, to be able to come and make a presentation about the facts of the case or the merits of the appeal, the demerits of it. We can just look at the record and say, are we willing to hear an appeal on this or not? Can't we?
Yes, sir. That's
And in
correct.
fact, we should do that before we hear from anybody, shouldn't we?
In the interest of fairness to the respondent, because he suddenly has stated that he would like to appear, I suggest that maybe you do reconsider this in September when you meet in East Tennessee, and he is located in Sevierville, so it would be closer for him as well. But I will leave that to the board to decide.
Well, yeah, I mean, I guess if you want to wait till September, that's fine with me, but at that time, I think we'll have to decide whether we even want to hear a bunch of discussion about it after we've read the record.
That's correct.
And we're not obliged to go anywhere with that. Am I correct about that?
Yes, sir.
So if we don't think there's merit in it, or if we do, then we can make a vote at that time, one way or the other.
That's correct.
Could
The
do
only
that
thing,
we could do that today, but you think it's best to wait till next time?
I will leave that entirely up to the board to decide. If you don't feel it's necessary to hear from him, there's no need to wait until the next time. He asked that he be allowed the opportunity to appear. I wish I hadn't heard from him at the 11th hour, of course, but
I don't know, if as few of these as we hear from, if he wants to come over there in September and
That's a good idea.
then,
right, but the case won't be presented to you. It is just whether you will hear an appeal at a future date. But he asked that you, yes.
Well, advise him that he will have a limited amount of time to talk.
Sir.
Make a presentation.
Please, go to page 3, and this is what I talked to y'all about earlier, something, not this, but the question I was asking. And go to number 5, trying to pull the permit.
Pulled it
he's
as
an
an
owner.
owner.
He's an owner.
Pull it as an owner
Yeah,
himself.
I'm guessing.
Well, if you're an owner, you,
Well, that's the whole dispute here, is whether he could actually do that construction.
I was asking earlier, I was trying to figure out, we get these unlicensed contractors, and I'm trying to find out who's at fault. Either them, or is it the municipality? Municipalities issuing permits, and they're not supposed to be issuing permits if you're not a licensed contractor. Now, if you pull it for your own house, I understand that. But if you don't, then they should not be issuing permits. It's just a matter, are they issuing permits, or are they really doing stuff illegally? Well, if you're doing stuff illegally, you can't get a final on your house when you get through building the house.
Yeah, but
So-
even if a municipality issues a permit in error, and they shouldn't issue one, it's still a violation to go get that permit if you're not licensed to do
Not
that
everybody
work.
knows that, Bill. Like in Shelby County, we're getting that all the time, and I'm having a hard time. And Carolyn, to tell you, our building department's issuing permits, and they shouldn't be issuing permits. And I have had a discussion with our head of our building department. And we've had a bunch of
Rampant
cases that come up
problem.
here.
Maybe we should get an injunction against them about doing that.
That's why we're sending that letter of information, isn't it? On that one matter where they issued a $4 million permit when the contractor was only licensed up to $1 million. I mean,
This is going on all around the state.
I'd like council to find out about the possibility of court-ordered injunction against them. What would it be involved about? Or back to the board.
You talking the injunction against them?
Oh, issuing permits that were for people who don't have a proper license.
Isn't that already the law?
It is the law, but you know, if they're violating the law, then we could have an injunction to prevent them from continuing that illegal activity. Certainly a function of the courts.
I'll look into it and see what we can do.
Maybe just the idea that we're willing to do that will make them understand that we mean business about it. Right, that's not right.
Well, I mean, I think I made the comment in committee that, I mean, it does seem to be more than just Shelby County. It seems like a lot of these permitting offices are just issuing permits and they never check to see if the person's licensed or not or what their limits are.
Right. They just after that dollar coming in their coffers, and they're not.
I mean, I think I could go out and just write, I'm the project owner underneath my name, whether I was or not, and I could get a permit today, probably.
Probably could.
They're gonna say that's not their job, is to check out whether you are or aren't, but testify to that, or you assign that. Are all the counties, or most of the counties on computer now? It used to just be a handful. Okay.
Back to this issue at hand on this appeal next time. Reese mentioned a time limit for the guy who wants to appeal. And I think he should be notified he's on a time limit, and I think we probably ought to tell him how much that time limit should be. 10 minutes, 15, 5? What do you think? Advise him he'll have 10 minutes to make his presentation.
Since it's a
Correct, and he does have appeal rights to Chancery, of course. But the first step is to, for the board to decide whether they want to hear the case. Thank you.
Bowman, our CPA in the office.
Good morning, ladies and gentlemen of the board. My name is Jay Goldman, and I'm one of your auditors. Mariana Bichet, your other auditor, and I have in the last 6 months run into 3 separate situations that are rather peculiar, and as a result, I asked Carolyn for the opportunity to present this to you to determine the board's will. 3 times in the last 6 months, contractors have submitted new applications or renewals with negative net worth due to a unique, unusual GAAP requirement regarding ESOPs, employee stock ownership plans. ESOPs are basically a transition device for a owner, founder, shareholder to transfer the business to his employees as a method of estate planning. In an ESOP arrangement, the company purchases the outstanding shares from the shareholders on an installment note and sells the shares for the same price to an ESOP on an installment note. Typically, you would have a long-term note receivable from the ESOP and a long-term note payable to the former shareholders. Oddly enough, GAAP requires that the note receivable from the ESOP be treated as a contra equity account instead of as an asset. Oh, Kathy, could you pass out those? They already have, thank you. Instead of as an asset. This treatment results in a reduction of the net worth for GAAP purposes. In the early first years of an ESOP ownership, this treatment will all but eliminate the net worth. What Mariana and I have found is that otherwise strong contractors cannot renew their licenses if there is no parent corporation with a strong enough balance sheet to offset the negative net worth. This seems a little unfair that we have to deny a renewal due to a quirky GAAP rule that pertains only to an ESOP. However, we are bound by the guidelines and rules to treat this in the manner unless the board can offer some guidance. The guidelines Mariana and I operate under when conducting our analyses are to take the GAAP-based financial statements and reclassify certain elements, such as related party and intercompany receivables and payables, that the board has determined are under management's control and may not necessarily be current assets or liabilities. Similarly, cash surrender value of life insurance, generally classified as an other asset, is reclassified as a current asset and included in the calculation of working capital. Precedence has been established for deviating from the GAAP presentation. The only solution I can see to an ESOP-caused negative net worth is for the board to direct the auditors to reclassify any ESOP contra equity accounts as a long-term receivable. This will not affect the working capital calculation, would give a more accurate picture of the net worth, and would allow contractors with otherwise strong financial statements to continue to conduct business in Tennessee. And I know this is all very technical accounting, so if I can answer or address any questions that you might have that I might have overlooked.
I think that only healthy companies would be benefited by this rule change.
Well, what I'm suggesting, if you look at the handout I gave you, the equity section shows the standard section of the equity section shows this balance sheet with $3 million of net worth. It's completely wiped out by that ESOP.
I see what
So
happened there.
I look at a $4.5 million. They would also have $4.5 million of assets, $3 million of net worth. When I look at the full balance sheet, that's a strong company, except for this ESOP.
But what I'm asking is, if we
Yes.
make this change that you ask, I mean, here's an example where obviously it would be the right thing to do.
Yes, sir.
Do you think in all or almost all of the cases that you're thinking about that would fix the problem?
The 3 that we've run across so far.
You've only had 3.
Yes, sir. 1 in December and then 2 in the last 2
And all
months.
3 of them are in the same boat.
Yes.
All we need a direct from the board. Move that we accept the recommendation that's been made.
Second.
Say good catch, good work. We've never had this happen in years that an audit.
Well, this
I want to
is,
say this, he did one also today with me, so, so he's 2 for 2 today.
this ESOP it's an issue that's been growing over the last few years, and my anticipation is going to continue to keep popping up. And after 3 within 6 months, Mariana and I felt it was nip it in the bud and get some guidance so that it doesn't keep recurring, and we can help, basically keep these contractors that are operating in the state, keep them operating in the state. It's a weird rule. There is no other receivable that the GAAP rules insist that you reclassify off the assets and into a contra equity.
Aye.
Opposed? Thank you very much.
Budget update. And what we have in the iPad is, this was a projection by Bill Huddleston, the department CPA, just to give you an idea of what based on the average money that we collect over the fiscal years, what we're going to expect at the end of this fiscal year. And we still don't have the numbers yet for the end of the two. Like it's pretty close on target what he's got. So we're still waiting for our final expenditures, the revenues, and the cost backs. But what he's got is probably how much will be going to the Go Build account is approximately over $2 million. And this leaves us with a balance with our reserve of about $2 million. And then based on what we have collected with the LLE and the LLP, our projected balance looks like we're gonna have about $3.7 million
Our reserve.
in our reserve.
Mr. Chairman, the deputy commissioner and the legislator that we talked with on the phone reaffirmed the ability of this board to make authorized expenditures out of this reserve fund. I'd hope that we're going to have the lady today to talk to us about public information spots and maybe talk about a possible budget for that. But one of the other things we had talked about was rule books. And I would like to move that we authorize the executive director to bring us back figures. Do you have to do a competitive bid on those? Yes. To bring us to get a competitive bid and let's print some books.
Second.
Those in favor?
Aye.
Opposed?
And One thing I did on the number of books, I've thought about this, and I really don't see any reason to mail every contractor a law book. I think maybe we should only print enough offices, throughout local government, maybe. Ask for about 5,000, because we do get them from the county clerk's office. Megan's not here, but that was one of the things she was gonna address. We were gonna see about, printing the books ourselves. Instead of putting it out for bid, she thinks there's a way that we can do it through state printing if we put it together ourselves. It won't look as nice as LexisNexis, but she says there might be a way that we can do that, and that was something she was going to address today. So,
Would that save money?
yes, it'd save a whole lot of money. Because right now it was the last bid we have. It was 14,000 for 1,000 books. So,
But let me, as an old printer in years past, the initial cost of putting together a publication is the biggest cost. So 1,000 may be that, but 2,000, it'll decline as you go up in the amount of money that you have to spend. So that's the usual thing with printing, is that the upfront putting it together cost, or the main cost of paper and printing, are not as nearly as high, and the more books you get, the less per unit cost that you're going to pay.
I would prefer it to be done professionally and.
You need to look at the cost.
You're gonna bring us a recommendation,
Yeah.
aren't you?
Okay. Go through the LexisNexis link on our website. So, they click on our site, and then they would have to know that it's 62-6, the title number and the chapter number. But we did get permission to take and print the book, which to print it directly from LexisNexis and put that in a PDF form. So we can do that. It won't look real well, because it's gonna. If you've ever went to that law site, it broke down one little piece at a time, and then you have to click and go to another one. So that, and put it in PDF form. But otherwise, what we do is direct them directly to LexisNexis, and we do list what the title number is. Not a good system.
Could go ahead and print all the LexisNexis and put it in PDF.
But then we, under the new business, we won't go build under the new business on the agenda, but we've already discussed. Have something come up in the meeting today, and Reese made a very good at the limited license, residential restricted licenses, the BCR, whether or not we need to continue interviewing these. Made a policy several years ago, probably back in the 90s when it first passed, and then when we did away with interviewing with all the contractors, we kept interviewing those. Today, we would like to ask you all if you want to continue to interview all the BCARs, or if you would like to change our policy.
I'll second it just to hear the theory behind this.
Now, that would be provided that they're in good standing, that the staff. Just like we get new license applicants all the time.
They still go through a board member,
Yes,
like any other waived applicant.
yes.
And if there's any problems, like any other waived applicant, we bring them up at that time.
Could still look at their files. Somebody will look at their files. They don't necessarily have to come up here. And then only time we'd bring them up here if we have a question.
What we do with basically everybody else.
Just like every other
Yes,
license
like every other
applicant.
Consider, how many BCARs do you deny?
We hardly deny any, but I think the original intent in having them come before us was, at the time, the monetary limit was 70,000, period. And we wanted to make sure that they understand that. I think we can probably convey that very same message through a document that is placed with their license and send that message to them.
And they're
You
taught
know,
that at the course.
urgently.
And there's no 10%.
Okay, but the license now is $125,000, so it's a little bit different than the 70,000. What I've had trouble with, even now, and I over theirs, I ask him, y'all know what a footing is? That we want you to go in and get your BCA license, so. But as long as it goes in front of some board member, that's fine.
They wouldn't be treated any different than our normal
Yeah.
$1 million.
Yeah.
Course does teach them about the limit. There's no overage.
Yes, I asked that specific.
Aye.
Opposed?
And the course teaches them.
Passes.
Our next meeting is September 29th, and our board chairman suggests
Are we staying at the Park Vista or
yes. Is it okay, or do you have another place you want me to try?
Park Vista's fine?
Anything else? Meeting adjourned.
Thank you so much.